The Supreme Court may soon weigh the enforcement of the Voting Rights Act after a federal appeals court drastically weakened the landmark law. The Eighth Circuit Court, based in St. Louis, ruled private citizens and groups cannot file lawsuits under Section 2 of the Act. It found only the U.S. Attorney General could bring a legal challenge under this provision. Section 2 prohibits election or voting practices that discriminate against Americans based on race. Jessica Levinson joins us now. She's a CBS News legal contributor and a professor for Loyola Law School in California. Jessica, this was a 2-1 decision made by three judges that were all appointed by Republican presidents. Talk to us about how the majority justified the decision.
So what the majority said here is that we have assumed for decades, and they mean since the passage of this landmark piece of civil rights legislation in 1965, we have assumed for decades that there's a private right of action, meaning you or I or a private group can say, my voting rights were harmed. There were voting practices and procedures that were implemented by a local official or state, and that harmed my right to vote. My right to vote is diluted because I'm a certain color, for instance, and that we could bring a suit. What the Eighth Circuit said today is, no, it's only the federal government, or excuse me, yesterday, it's only the federal government. It's only the Department of Justice that can bring those suits. What I think is important for people to remember is that the vast, vast majority of those suits are brought by individuals or by nonprofit groups. So this would eliminate a huge avenue that people have to vindicate their right to vote, and it would put enormous pressure on the federal government to try to step in and fill the vacuum. There's frankly no way that any Department of Justice could possibly do that.
So I think, Jessica, people will be wondering why this happened, because it sounds like the real impact of the decision is to make it much harder for people to have action taken if people are discriminated against when they try to cast a ballot.
That's right. So what we have here are two judges who looked at the wording of the Voting Rights Act and, in my view, took a incorrect approach to just looking at the words and saying, you know what, we've always assumed, but we've never found that there's a private right of action. I'm looking just at these words, and I don't think that there is a private right. I think it has to come from the federal government. Now, that, in my view, goes against not just decades of precedent, not just the Supreme Court assuming that private individuals and groups can sue, but also goes against the legislative history. Let's think back to why the Voting Rights Act was enacted in the first place, because people's right to vote was under threat and because we wanted people to be able to vindicate those rights. One other thing I think that's important for people to remember, this is the Eighth Circuit. About 10 days ago, the Fifth Circuit came to a different conclusion. But what's the Eighth Circuit picking up on here? It's Justice Gorsuch on the Supreme Court and Justice Thomas, who have both indicated that maybe we need to look at this issue. I think they're picking up on those cues.
That's interesting, and a very good point that you raised, Jessica, that different courts are coming up with different decisions on this. At this point, if the Supreme Court doesn't take it up or before they do, what options are left for people who felt like their right to vote was blocked?
So in the Eighth Circuit, there can be an appeal to the entire panel, an en banc appeal to try and say these two judges were wrong. At that point, they're kind of out of legal options. They need to bring this case up to the Supreme Court.
All right, Jessica Levinson, thank you.
Thank you.